we want to get away on this very special night, this 7th Hobart Oration, which is organised by our Bob Brown Foundation, which I hasten to add is not a superannuation fund, but is a voluntary, it's based on voluntary gifts organisation, which is here to help ensure that our planet's every bit as beautiful when we leave it as when we found it for future generations to come. We welcome you to contact us if you want to. There's a board outside with the details on it. But one of the things we do is work in public service to stimulate public debate on issues of great moment, and hence the Hobart Oration, and hence, as you know, my proclivity for a little bit of Tasmanian innovation and excellence in innovation at the outset. I will be introducing our guest speaker, Professor Gillian Triggs, very shortly. But before that, I want to introduce our special musical performers for the night. Once again, Michael Kieran Harvey, who's on the piano, and Emily Shepherd with the violin. And you'll find that this piece is not what you were expecting. I found that because Michael did me the honour of coming down to Bathurst Harbour with a few others last year, and I think this came after that, but whether it did or didn't, Michael might say a few words in introducing this piece of Tasmanian music to get us underway for the evening. It'll be about 10 minutes, and then we'll be on with the oration. Thank you, Michael.
I'll be as brief as possible. Really, both of us feel, both Emily and I feel in Green's royalty here this evening, so it's quite intimidating. This piece of music, Portrait of Bob Brown, I think it's probably the first portrait in music of an Australian politician or ex-politician, certainly a leader, and who better than Bob Brown? This piece is like a series of snapshots of Bob's life. Bob is a keen photographer. It is a very strong piece. It's not an easy listening piece. It represents struggle, it represents triumph, it represents hope, if you like. But it was my interpretation and my homage to Bob and all that he... And for that reason, I hope you'll bear with it. We have a most wonderful soloist in Emily Shepherd, who is an eco-warrior. The piece was commissioned by Dr. Arjun von Kamera, who also helped fund the recording and donated lots of these recordings to the Bob Brown Foundation for revenue raising for the foundation. So please, if you feel so moved, please buy a copy if you can. And yes, as Bob is a great photographer, it's in a series of about 5 sections which are trying to encapsulate his spirit and what he represents. I hope you enjoy it.
Thank you, ladies and gentlemen. Now you know what I look like. That piece of music has come from the inspiration of Tasmania. I heard more than possums in that music. There were, I think, a few, maybe there was even a paddy wagon or a bulldozer in there. But thank you very much for that remarkable composition and the absolute brilliance with which it was played. Well, I want to thank a few people for getting us here tonight. Firstly, Stephen Chaffer from our foundation, who's done an enormous job of getting this event to fruition. Jill Parsi, who was our volunteer event organiser. Angela Bain, voluntary for her voluntary assistance. Sarah Jane Larda, graphic designer, did the posters, brilliant posters, flyers and ads. Kelly O'Grady and Sarah Bamford, who are at the other end at the Human Rights Commission staff. And of course, Gillian and Sheila for the flowers which came tonight, and then a big team of volunteer ushers. Thank you to you all. You might know that there's been some contention about our very special guest tonight. In fact, the front page of the Daily Telegraph in Sydney was devoted to calling off the event so that we Hobartians, apparently very secondary to the paper which devotes itself to New South Wales, wouldn't get to hear from one of the most thoughtful, intelligent and courageous Australians on the public, in the public eye in 2017. Notwithstanding that story, which had so many, a wrong headline and so many wrong factual errors. By the way, the journalist never called me about it beforehand, and when I suggested that she have a phone conversation the day after, she didn't comply. That's not in the Journalist Code of Ethics I last read. But for those of you who did read the article, it said on page 1 that tonight was a $50 a head dinner. I'm sorry the canapes are late. And you may have to get your own fish and chips after the event. I'm just delighted that this oration is taking place in this remarkable town hall of ours in Hobart, which has seen so many great speakers and orators over more than a century and a half in the past, and that tonight's guest is Emeritus Professor Gillian Triggs, who's President of the Australian Human Rights Commission. She was Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney from 2007 to 2012, and Director of the British Institute of International and Comparative Law before that from 2005 to 2007. Gillian Triggs is a former barrister and a former Governor of the College of Law. She has combined an academic career with international commercial legal practice and has advised the Australian and other governments and international organisations on international legal and trade disputes. Professor Gillian Triggs' focus at the Commission is on the implementation in Australian law of the human rights treaties to which Australia is a party, and to work with nations in the Asia-Pacific region on practical approaches to human rights. Professor Triggs is the author of many books and papers on international law, including International Law, Contemporary Principles and Practices in 2011. To that I add, Professor Triggs has spoken all over Australia and internationally. She has been a champion of human rights in an age which sorely needs it. She is a person who has stood for justice and the law against sometimes a tirade of criticism and condemnation by people in our open and free democracy who I think should know better. But I have heard her speak on many occasions through our instruments of the media, and it has always given me the feeling that indeed here we have a champion of what it is to be a human being anywhere on the planet, and there are 8 billion of us in 2017. She makes me proud to be Australian. She makes me feel that our national motto of having a fair go is still alive and in the public discourse. This remarkable Australian is a fearless defender of those who don't have a voice for themselves or those who are struggling simply to find their rights in a planet where so many people are deprived. So, ladies and gentlemen, it's my great pleasure to introduce our 7th Hobart orator, Professor Gillian Triggs.
Thank you, Bob.
Thank you.
Thank you very much. Thank you very much. Thank you. Thank you very much indeed. Well, what a wonderful welcome. Thank you all so much. Thank you, Bob, for that introduction. In fact, Bob reminds me, in introducing me as an emeritus professor, I was told by an old friend of mine that emeritus is Latin for has-been. Well, I'm not quite a has-been just yet. Thank you, Michael and Emily, for that wonderful music. I really enjoyed it. And it is a wonderful portrait of Bob, sort of a great spirit, disruptive, passionate, and demonstrating the kind of leadership that he's shown in Australia over many, many years. It had some calm and peaceful passages in that music, so I hope that Bob and Paul, you have some peaceful times now you're out of the maelstrom of politics. I am, of course, very honoured indeed to have been invited to Hobart to give this 7th Hobart Oration. And in this glorious hall, which I understand in the town hall it's 175 years old, may I also acknowledge the traditional custodians of the land, the Palawa people of Tasmania, and respect their elders, especially if there are any here this evening. Well, because of the political controversy about the lecture tonight, I did make it my business to learn a little bit more about the Bob Brown Foundation to make sure it wasn't a superannuation fund. And I was very pleased indeed to read that it promotes, of course, the unique beauty of Tasmania, but it also talks about the idea of ecological integrity and human happiness. As an international lawyer, I've long maintained an interest in protecting our environment, not only for its own sake, but as an aspect of the human right to a clean and sustainable environment. I first came to know Tasmania many years ago in the 80s as a member of the Commonwealth's Antarctic Science Advisory Council. I went to Antarctica in 1986 on what was described at that time as a round tripper or a jolly for the advisor to the then marvellous Minister for Science, Barry Jones. And you'll remember, of course. And I was in the company of sailors and scientists, artists and plumbers, and I travelled on the German ship, the Icebird, taking 12 days to get to all of the Australian bases. And I was away for about 9 weeks. But when I first boarded the ship at Salamanca Place, I was the only lawyer on board. And I was referred to frequently, in fact, by a number of people as a Jaffa. Now, there may be some people in the audience who remember what a Jaffa is, those rather hard, round sweets with orange casing. But I plucked up the courage after a few days to say, well, you know, what's a Jaffa? And they said, just another F academic. Well, this was a less than welcoming start, but it didn't spoil what for me was the experience of a lifetime in understanding something that matters to me, and that is the success of international law in preserving the Antarctic environment in the interests of all humankind, because I do believe in law deeply. And the Antarctic Treaty System has been one of the success stories of environmental diplomacy and of international law in preserving national claims to sovereignty, while at the same time creating a sustainable international regime in the interests of all of us and the common heritage of mankind. But I haven't come tonight to talk about the Antarctic Treaty, although I love to talk about it. Rather, I'd like to consider a much more troublesome subject, and that is the protection of human rights and the idea of a fair go in Australia today. Over the last nearly 5 years of my appointment as President of the Australian Human Rights Commission, I've learned some powerful lessons. It's one thing to advise a commercial client, as I have done, about the law, or to lecture law students about the role of international law in Australian law. But it's quite another to stand in the heat of Christmas Island and to explain to a mother clutching her baby that the Convention on the Rights of the Child does not apply directly in our municipal and legal system in Australia. It will not protect her child. In short, over the last few years, I've formed from a rather conservative international and commercial lawyer to an advocate for human rights and to a critic of some government policies, particularly those policies that fail to meet the international legal standards that we have accepted and signed up to in international law. Perhaps the most important lesson I've learned, and the focus for my discussion tonight, is that a fair go is not just another empty phrase in an age of slogans. It's a commitment of Australians to fundamental principles of equality, fairness for all, and justice, a cultural norm upon which I believe our Australian democracy depends. It's this cultural commitment to fairness and equality that's proved vital when our constitutional, parliamentary, and judicial regimes have failed dismally to protect some basic rights and freedoms. Well, let me explain what I mean. Perhaps, in my view, the most disappointing aspect of Australia's failure to protect human rights has been the failure of Parliament itself. And you'll remember that last year, 2 years ago in fact, we celebrated the 800th anniversary of the Magna Carta, when King John, on the soggy fields of Runnymede, was forced by his feudal barons to put his seal to that document and to accept that the sovereign is subject to the rule of law. Since that time, Parliament has been a primary restraint or check on the executive power of governments. But of course, governments or executives always overreach. It's in their DNA to expand legislative and discretionary powers and to avoid judicial scrutiny. It's been through democratically elected parliaments that the overreach of executive governments has been restrained and that fundamental freedoms have been recognised, evolving over the centuries. If we fast forward to the 21st century in Australia, it's become true that respective federal governments, and on occasion linking with opposition parties, have acquiesced in passing laws introduced by governments that breach our rights. One might date this trend from 2001, and you might recall that year. It was the year of the children overboard false news, although we didn't use that term then. The arrival, a few months later, of the Tampa, carrying asylum seekers into the territorial waters of Australia and to Melbourne. And then, a few weeks later, the terrorist attacks on the Twin Towers and the Pentagon in the United States. Since that time, we've seen a steady erosion of common law freedoms and the adoption of laws that breach Australia's treaty obligations. Let me give you some brief examples. One I think you'll be very familiar with. Australia is the only country in the world that mandates the detention, often indefinitely and, in my view, arbitrarily, of asylum seekers and refugees. Parliament has passed provisions of the Migration Act that require detention without meaningful access to the courts. On Christmas Island, at Villawood, where I'll be doing an inspection visit next week, Yonga Hill and Mitre, in some cases for many years. Worse, that legislation now requires the transfer to Manus Island and Nauru of those who are claimed to be unlawful maritime arrivals. At the moment, 50 children and about 400 adults remain on Nauru, about 850 young men, typically young men, remain on Manus Island, and 1,500 people remain in held detention in detention centres throughout Australia. And I'd like to take this opportunity, if I may, that when we came down, the team from the Commission came down to Pontville to look at the conditions for the children and families when they were then held here in Tasmania, we were all really delighted to see how the community had responded so positively to the plight of these families. They opened their arms, helped them into schools, embraced them within their communities when they were released. And we felt that this was really one of the most positive environments that we'd seen throughout Australia. Well, I think you're all familiar with that continuing tragedy, but others perhaps you might not be so familiar with, or perhaps haven't followed because of the complexity of the laws, are the endless amendments to laws in counter-terrorism. These laws threaten freedom of speech and freedom of movement, and I believe that they've become an overreach that fails the legal test of necessity and proportionality. A recent example being the passing of laws by Parliament to place control orders on 14-year-olds and indefinite preventive detention for those suspected likely to commit a terrorist act in the future. The criminal law has never permitted this as a matter of history. But we also have other laws that I think we've almost become used to, requiring the retention for 2 years of metadata. Is an overreach, in my view, of power that restricts the privacy of all Australians. You might know that in order to look at your emails, governments must have a warrant. But if they want to look at your metadata collected over years, and metadata being everything that you've done, all of the data that connects you up with who you phoned, how often you visited certain places, all of this is accessible to government authorities without a warrant. And in fact, you can learn a great deal more from metadata about your lives than you ever could from the content of an email. But we've largely accepted that, and indeed young people are likely to shrug their shoulders and say, well, I haven't done anything wrong, so it doesn't matter. So we don't really know the consequences of these. In Australia, we have incarceration rates of Indigenous Australians that the United Nations says are the worst in the world. In the Northern Territory, 95% at least of those imprisoned are Indigenous, and I'll come back to that in a little while. We have laws that continue to be passed threatening freedom of speech. The Border Force secrecy provisions impose a 2-year prison sentence on social workers and teachers and contractors who report on the conditions in refugee detention centres. Counter-terrorism provisions restrict speech and movement. Defamation laws have a chilling effect on speech. But of course, the right to freedom of speech, that is something of a slogan by many and is underpinning the inquiry into the Racial Discrimination Act provisions that prohibit the abusive racial speech. Those rights to freedom of speech can equally be abused. And in my view, many in the media do abuse that right to freedom of speech and fail to understand that it's to be balanced with other rights in the community. Sadly, many media outlets distort the facts on ideological grounds, and disturbingly, politicians feel free to say anything they like in Parliament under the privilege of parliamentary immunities. We have prohibitions on the right to strike in Australia that are far more restrictive than exist in comparable jurisdictions, and we have a ministerial discretion now proliferating in legislation that is not either, it cannot be required, it cannot be challenged in the courts, it is simply a ministerial discretion, so that we can now strip the nationality of dual nationals of their citizenship in Australia, and we can withdraw visas on character grounds at the discretion of the minister in ways that are not subject to judicial review. And some of the numbers that I mentioned of those in detention, particularly those on Christmas Island, are in fact not asylum seekers, but they are people who failed the character test, and those numbers are now rising. Well, in contrast with legislation that positively breaches human rights, Federal Parliament has also proved unable to act in respect to a number of contemporary and important issues. The marriage equality plebiscite has failed. Despite strong community support, Australia remains one of the few comparable nations in the world that denies the right to equality under our marriage laws. At the Human Rights Commission, we believe that equality before the law is an inalienable human right and not appropriate for popular votes. It's for Parliament to amend the laws to reflect changed community standards, not to transfer that responsibility to a popular vote. Indeed, it's worth recalling that the United States Supreme Court decision a year or so ago on marriage equality in the Obergefell case based its provision that now applies throughout the United States on the Bill of Rights protection of equality before the law. The Australian High Court has no such power to resolve the issue. Parliament has failed to prevent the reduction of funding for community legal services, threatening the right to legal advice and access to our courts and tribunals. And we found again that Parliament has failed to provide workable solutions to proposals that the now notorious Section 18C of the Racial Discrimination Act be amended. The Parliamentary Joint Committee that inquired into this over the last 4 months was able merely to set out a list of possible reform options and failed to provide either policy analysis or a recommendation for legislative change. Indeed, the government is debating tonight, I understand, proposed changes to the Racial Discrimination Act that the inquiry itself noted attracted no more than one supporter in that committee. The other issue that I think you'll be aware of is the failure of Parliament to lead in the constitutional recognition of Indigenous peoples. I was very fortunate to be in Canberra in Parliament House when Mr Abbott and Ms Gillard as Prime Minister agreed to legislation to move forward to set up committees to promote and provide language for constitutional recognition. They agreed with each other, and it was a unanimous vote of Parliament. It was a wonderful and inspiring day to be in Parliament, but I think you all know that the matter has largely dropped off the political agenda, and we no longer seem to have leadership in the political sphere in relation to what might be proposed in the future. But in addition to these failures of Parliament to lead and to protect our rights, we've also seen a failure by our courts over the last few years to take into account our common law freedoms or the obligations that Australia has accepted in the treaties to which we're a party. But it's not always been so. Receding into the mists of time is the liberal jurisprudence of the High Court of Australia in the 1980s and early 90s that gave us Mabo No. 2, recognising native title, and the Teo case that raised, controversially, a legitimate expectation that our government officials will take into account the rights of the child under the Convention on the Rights of the Child. You will all, of course, especially remember the Tasmanian Dams case that confirmed the wide reach of the external affairs power under the Constitution, empowering Parliament to ensure international treaties on issues ranging from world cultural and environmental heritage to decriminalising homosexual acts can be implemented by the federal government as part of Australian law under the Constitution. But that was the 80s and early 90s. By contrast, today we have a High Court that makes decisions, for example, in the Alcatab case, that considered valid the mandatory immigration detention laws in respect of a stateless man who was held for nearly 5 years on Christmas Island and at Villawood, or the so-called paperless arrest laws of the Northern Territory that allow the arrest and detention of persons for up to 4 hours without bringing them before a magistrate. So my question this evening is, how is it that Australia has become exceptional, even isolationist, in failing to protect our fundamental freedoms? Why have we drifted so far from our English common law roots to allow laws that are at variance from the human rights protections available in the United Kingdom, throughout Europe, Canada, Africa, Latin America, even our cousins in New Zealand? In fact, I love that segment of the transfer, the Rowan transfer. What would Justin do? We now look to what Canada would do under this extraordinary new Prime Minister, making a point, of course, about how important leadership is in ensuring that these basic rights are recognised. But an illustration of how far out of step Australia has become in relation to other nations is a stark contrast between two relatively recent decisions, one by the Papua New Guinea Supreme Court and the other by the High Court of Australia. You might recall that the Papua New Guinea Court considered the constitutional validity of the detention of now about 950 men on Manus Island. And the judges of that Papua New Guinea Supreme Court decided unanimously that the indefinite detention of these young men, most of whom have been assessed by proper processes in Papua New Guinea as meeting the legal standard for refugee, to continue to detain them on Manus Island was a contravention of the Papua New Guinea Constitution and a contravention of Papua New Guinea law. In striking contrast, just a few weeks later, the High Court of Australia decided, in what is not very excitingly called the M68 case, that the removal of asylum seekers, in this case a Bangladeshi woman also adjudged to be a refugee, could be removed from Australia to Nauru for detention, and that this was constitutionally a valid exercise. Now, the question I ask is, what is the difference between these two cases? And the answer, I'm afraid, is that Papua New Guinea is the more modern constitutional democracy with a Bill of Rights. Australia is unique among comparable legal systems in having very few legal means to protect our freedoms. We do not speak the language of international obligations or human rights when we discuss public issues. And when the United Nations Rapporteurs and Human Rights Council have raised concerns about Australia's failure to protect vulnerable people, Indigenous Australians, women in domestic violence situations, and asylum seekers, including a report from the Rapporteur on the Convention on Torture that the detention conditions on Nauru and Manus breached that convention, the response from Canberra was, "We will not be lectured to by the United Nations." So when considering the question that I've posed as to why we've drifted into isolation, I should, in fairness, recognise that Australia's role in protecting civil and political rights and non-discrimination laws has been one of genuine global engagement, leadership and commitment historically. Some of you will remember the extraordinary legacy of Dr. Evatt. He was, I think, I'm told, irascible, determined, a brilliant lawyer, and he was extraordinarily for those times in 1944 at the Dumbarton Oaks, responsible for some of the most important provisions of the Charter of the United Nations, one of the documents that has inspired me as a young lawyer when I studied law in the 60s. He was then invited back to the United States by Eleanor Roosevelt to draft and help draft the 1948 Universal Declaration on Human Rights that underpins all of the modern law that has developed in relation to the protection of universal human rights. And she, Eleanor Roosevelt, worked well with Doc Evatt, and he pushed through a lot of very important clauses. But importantly also, perhaps we forget in Australia, he was president of the General Assembly when the declaration was introduced, and it passed without a single negative vote. And there's a wonderful window in New York, in the UN, if you go and visit it, to Clive Evatt, because he is seen as a man who really did push through those remarkable documents. So my point in raising the legacy of Evatt is that historically we've punched well above our weight. We have made a strong commitment to the foundations of modern human rights law, and we've been a prime mover in drafting, negotiating, signing and ratifying all of the major international human rights treaties: the International Covenant on Civil and Political Rights, the Covenant on Economic, Social and Cultural Rights, the Convention on the Rights of the Child, the Refugee Convention, of course, in 1958, and all the discrimination conventions on race, sex and disability. Indeed, we were the leader. We had legislation on disability discrimination before the international community did, and our legislation actually led to the language adopted in the Universal, in the Declaration on the Rights of Those with Disabilities. We were also a leader in the conventions on genocide and torture, and right up until the mid-90s, we were a leader in creating the statute for the International Criminal Court, which is now operating. But sadly and extraordinarily, these international initiatives have not, for the most part, been translated into national laws, and therefore they're not binding on the courts or on Parliament. There are some exceptions. The important exceptions are three. The disability one that I've mentioned, because we were a leader in that area anyway, the Race Discrimination Convention brought into Australian law by legislation in 1975, and CEDAW, the sex discrimination legislation that under that marvellous colleague of mine, Susan Ryan, at great personal cost, she was vilified for suggesting that women should be treated equally in the employment area, came into force in 1984 in Australia. So we have had a few successes, but for the most part, the suite of international law does not apply in Australia. And to our shame, some of the provisions of the Refugee Convention that did apply in the Migration Act have been eliminated in the last 2 or 3 years, deliberately eliminated. And the definition of a refugee now under Australian migration law, is the Australian government's view of what is a refugee. And one of the many ironies, as I mentioned a moment ago, is that Papua New Guinea and Nauru went about in a rule of law based way to determine whether the people who landed in their detention centres were refugees, and they decided that on average about 80 to 85% met the legal definition. In Australia, we have about 30,000 people whose claim to refugee status have yet to be determined. We simply froze the process and left these people in our community without the legal status and dignity and recognition of being a refugee. But Parliament has got away with this, and that is really one of the things that disturbs me very greatly. But why? Why is it that we've moved in these directions? Well, one of the reasons, and I've alluded to this, is that Australia is the only common law country in the world that does not have a charter or Bill of Rights. And almost all civil law countries also have a Bill of Rights. We are truly exceptional in not having benchmark provisions, so that when I mentioned the Obergefell case in the United States Supreme Court has a Bill of Rights, the 14th Amendment, equality before the law, and simply reached a conclusion in a very powerful judgment, particularly by Justice Kennedy, if you've got time to go and have a look at it. But the point is, we don't have those benchmarks to hang our concerns about human rights. And indeed, it's been one of the ironies for me to observe that the push for some basic benchmarks in some form of Bill of Rights has come from Victoria, which has a charter, the ACT, which has a very advanced charter, and now I understand under the Palachuk government, the Cabinet has agreed that they too will move to a charter in Queensland. So we may have more of a grassroots approach to establishing a charter eventually than we do at the federal level. So that's the first point. The second point is that we have a very practical constitution, but it's not an inspirational document, and it's not one that protects many human rights. Under our constitution, we have a right to vote, we have a right to compensation if our property is taken from us, we have a right to trial by jury on some matters of indictment at the federal level, and we have a right, importantly, to freedom of expression of religion. But all other freedoms depend for protection upon other sources, most particularly the common law and our courts. It's rested, for example, with the High Court to imply a freedom of political communication, a right that does not fully equate to the common law or international law right to freedom of speech. So we have an unusual situation. No Bill of Rights, very few constitutional protections for freedom of speech, freedom of movement, and so on. We've ratified the international treaties but not implemented them in the main in domestic law. But we also live in a very unusual part of the world. because in the Asia Pacific, we're the only region in the world that does not have a uniting convention on human rights. There are human rights agreements for North America, Latin America, Africa, Europe, the Middle East, but nothing in our region except a relatively weak document by ASEAN. A good start, I think. I'm all in favour of it, but nonetheless, nothing like an agreed regional Asian commitment to human rights. So we don't have an evolving jurisprudence, and the jurisprudence on human rights from the United Kingdom courts, from the French and German courts, or the US Supreme Court are not valid in Australia because everything in their law is viewed through the prism of their human rights laws, and not so here. If you've been to New Zealand recently, you'll know that they've just celebrated the 21st anniversary of their Bill of Rights, and you can't discuss any issue in New Zealand without seeing how it fits with their own Bill of Rights. The sky has not fallen in New Zealand, and they seem to have managed their respect for their Indigenous peoples in a way that's truly inspirational. Different from our situation, admittedly. It's much more complicated in Australia, but it shows that every other country, certainly of comparable legal background to ours, has managed these issues of protecting rights in a way rather better than we have. Well, you might say, that's all fine, but what about the common law? Now, I've mentioned the Magna Carta. Let's go back and look at the common law freedoms. And there's no doubt at all that our courts and our judges will repeatedly emphasise that they will not interpret a statute from Parliament if it encroaches upon common law principles, if it is clear, if it is clear that the right was not intended by Parliament to be breached. Or put another way, the common law principle will not apply if Parliament has made it unmistakably clear that it intended to override the international law principle. Now, when you hear the courts talk about this, they will emphasise the common law principles and the presumption that the common law rules will apply. But the reality, the harsh reality, is that in the contested areas of migration and counter-terrorism laws in particular, there is usually a crystal clear legislative statement by Parliament so that there's no ambiguity and the courts cannot and do not have the power to apply the common law principles. Now, it's interesting, of course, that Sir Gerard Brennan in the Mabo case was able to reach out to international jurisprudence to say that the principle of terra nullius no longer applies in Australia. And he did so by processes of interpretation. But he did it, along with, of course, a majority of the court, he did it in a way that respected common law principles of recognition of a people's within territory that is acquired. So although the common law does protect our fundamental principles, the truth is that over and over again, appeals to the common law do not succeed because Parliament has been clear in its intent to override those principles. And you might remember one example, the Malaysia solution. You remember we were going to have a rather bizarre swap with Malaysia. They were going to take 2,000 and I think we were going to take a few hundred. Whatever you think of that arrangement, it was challenged before the High Court of Australia, and the High Court read the Migration Act and found an interesting provision in there, Section 198A, and it said that the Minister cannot engage in this kind of swap arrangement unless Malaysia is a party to the Refugee Convention and will protect the rights of refugees. So you'll remember the Malaysia solution failed at a political level and ultimately at a legal level. What did the government do? It went straight back to Parliament and it took that relevant Section 198A out of the Migration Act. Now, for political reasons, they've not pursued that concept of a swap. But nonetheless, it demonstrates that no matter what the courts try to do, using what tools they have, and they're few, they can always be overridden by the power of Parliament. Well, it's in that context that the Australian Human Rights Commission itself becomes relatively important. There are 117 human rights commissions throughout the world. and some of them you don't hear very much of because they exist in an environment in which you've got bills of rights and legislation and constitutional protections. But I'm afraid the Australian Human Rights Commission has assumed perhaps a stronger role in this environment because there are so few other mechanisms within our system for calling the government to account. And we do have an extraordinary statute that requires the President to call to account, to hold to account the private sector and the public sector, the government, for compliance with the discrimination laws that are part of Australian law, but also with the international human rights treaties to which we are party. Now, if you've really been listening to what I'm saying, you will know that that's part of the problem, because the treaties that are part of my jurisdiction aren't part of Australian law. So when I go and see Mr. Dutton or Mr. Scott Morrison or any of the other ministers that I need to talk to, they'll say, that's very interesting, Gillian, that there's a right under the Convention of the Rights of the Child, or the Refugee Convention provisions, or the International Covenant on Civil and Political Rights applies. And they'll say, but they do not apply in Australian law. You can call us to account, but there's nothing whatever you can do about it. So when I go to the federal court through, obviously, lawyers, and typically I might add, I'm very proud of my profession, pro bono lawyers, take a matter to the federal court, or we go to the High Court. Most frequently, we lose in making arguments based on these fundamental freedoms, because the legislation, particularly the Migration Act, counter-terrorism laws, are so crystal clear that there's really little that the courts can do. Well, there's been a lot in the news about our complaints process. I won't spend a lot of time on it, except to say that I do believe we provide genuine access to justice for about 22,000 people a year. They come to the Commission with their complaints, we try to conciliate them, and we conciliate about 76% of them. But one of our major roles, of course, is advocacy, and it's advocacy for the very principles of human rights law that are not actually amenable to implementation in the current legal position. But what I've said so far is perhaps a little abstract and perhaps a bit full of law. But let me now turn away from the abstract to a specific example that I think touches the hearts and minds, as well as perhaps the intellect in this area of concern, and that is the Ms. Du case. And her story is illustrative of a range of human rights abuses that tend to cluster or accumulate in one tragic tale. Ms. Du was a 22-year-old Aboriginal woman in Western Australia, and in August 2014, the police were called to Ms. Du's house by her grandmother because Ms. Du had been subject to domestic violence at the hands of her partner, a sad but not infrequent story. When the police arrived, they do what they always do. They checked her background and record, and they found that she owed $3,000 in fines, parking, traffic offences, very minor matters, adding up to $3,000. So they arrested her, and they took her to a police lockup in South Headland in the Kimberley. She complained of pain from the violence that she'd suffered, and she was taken by the police from the lockup to a local hospital, where it is alleged that the police told the medical staff that she was faking it. She was diagnosed by the medical staff with a behavioural issue and discharged back into police custody at the lockup. Again, over a few hours, she complained of illness, and she was again taken to the health facility, and she was again returned to the police when the medical staff provided them with a form that said she was fit to be returned to custody. This third time in custody, CCTV footage showed her writhing on the floor in apparent agony. This time she was put into the police van for the third time and taken to hospital, where she was dead on arrival. She, it seemed, had died from the fractured ribs of the violence from septicemia and pneumonia. It has taken 2.5 years for the coroner to report, but the coroner, if I may say so respectfully, has done an excellent job, because she looked at the story of Ms. Du, the long history that led to this very, very sad story. and indeed underlies so many of the Aboriginal deaths in custody that we continue to see. Her story is one of hundreds, and the coroner mentioned in particular about 80 Indigenous and non-Indigenous women are killed every year by their partners or former partners. People are imprisoned under unjust fine systems. Hospital staff are not always trained to understand these problems. Police can be overworked and frustrated. Support services are underfunded. But that sad story brings me to a much broader point. You might recall that 26 years ago, we had the inquiry into Aboriginal deaths in custody. It's shameful that over 300 recommendations of the Royal Commission into Aboriginal deaths in custody in 1995 have yet to be adopted. Fundamental to these recommendations is the observation that Indigenous Australians are detained more often and for longer periods than others, contributing to their disproportionate deaths in custody. Today, 26 years later, Indigenous people in detention have more than doubled in numbers since that time. The unpalatable fact is that over 95% of juveniles in the Northern Territory system are Aboriginal. The national figure is 55%, whereas, of course, Aboriginal peoples throughout Australia number fewer than 3%. Almost all adults imprisoned on criminal charges in the Northern Territory are Indigenous. Well, of course, I think you can see that I'm leading to the shocking CCTV footage that we saw of the demeaning, debilitating and dehumanising behaviour that has prompted the creation of a Royal Commission and has really captured the imagination of the Australian community. The Royal Commission has unprecedented powers of investigation that includes, very importantly, whether these acts violate the Convention on the Rights of the Child. So although that convention is not part of Australian law, it is part of the jurisdiction of this Royal Commission. And we really hope that this time the Royal Commission's report will drive change. But it's an interesting point that it's the iconic picture that can drive political change. For my generation in the early 70s, it was the picture of a 10-year-old girl with napalm burns running down the street in Vietnam, in Hanoi. Or it might be the crumpled body of a 4-year-old Turkish boy who drowned and washed up on the shores. For us, I think it's the picture of a 17-year-old Indigenous young man strapped into a steel restraint with a hood over his head. And you've seen the CCTV footage of the stripping naked of these young boys and the use of tear gas. Now, it is interesting that others have reported on these practices over the years, including the Children's Commissioner in the Northern Territory. And I reported to the Commonwealth Parliament on a particular case that had been the subject of complaint to me. I reported he'd been subject to 17 times the use of this steel restraint, contrary to any fundamental principle of civil and political rights. But it was lost in the political processes. It was never mentioned again. So it took that photograph to start us to think about what it is we're doing to these young juveniles who need, I think, a much different form of approach. But where all of this leads me to is, again, the failure of our parliaments and our courts, because of a particular example that's been troubling, and that is the so-called paperless arrest laws passed by the Northern Territory administration. Those laws allow the police to hold in custody anybody for up to 4 hours without a warrant in relation to any particular offences. And in the second reading speech for this legislation, it was said quite blatantly that the reason was to avoid the paperwork for police in arresting individuals. I could hardly believe that anybody would actually admit that that was one of the reasons for allowing this. Now, it's exactly contrary to the Royal Commission 26 years ago on Aboriginal deaths in custody, and what it's led is to a spike in numbers of those held in prisons in the Northern Territory. And shortly after that legislation was introduced, A Walpiri man, Mr. Langdon, died of heart failure in custody, having been arrested for 3 hours under the paperless arrest laws. The coroner in the Northern Territory warned that this law had a disproportionate impact on Indigenous Australians and should be repealed. The matter went to the High Court of Australia, and the High Court of Australia said that it was the common law rule is, and one that I learnt in law school, it's been around for a very long time, anybody arrested by the police must be brought before a magistrate as soon as is practicable, but certainly as quickly as possible. The court acknowledged that that was the common law rule, and then said the Northern Territory provision trumped it. I shouldn't use that word. I'll come up with another one. But you see what I'm saying, that fundamental principles that have been so destructive for our Indigenous Australians cannot be overridden in the interests of common law freedoms, even by our High Court of Australia, because of the power of Parliament. Well, let me come then very briefly to the 18C problem of the Racial Discrimination Act. I probably don't need to remind you, but that makes it an offence, a civil offence with no sanctions, and civil offence to offend, insult, humiliate or intimidate somebody in the public arena because of their race or national origin. It's quite a simple provision, and it's been there for 20 years. The government is now proposing that the language offend, insult and humiliate be taken out, and that the word harass be included. The curious phenomenon is that harass is defined for the purposes of the Sex Discrimination Act of 1984 to include offending and humiliating. I do not understand this circular analysis and the really very poor drafting, but I raise the issue with some hesitation, because your Senate representative, Jackie Lambie, and the leader of the National Party, Barnaby Joyce, have both observed, and echoing John Alexander's concerns, that Section 18C is not in the top 100 issues about which politicians are questioned by their constituents. It's simply not relevant. An Ipsos poll recently said that 78% of Australians were against the changes, but much ink has nonetheless been spilt on the question of whether Section 18C and the freedom of speech defence in 18D get the balance right. Reasonable minds can ask the question, and should ask the healthy question: is the balance between one freedom with another right? We should review and consider these matters regularly. But we know at the Australian Human Rights Commission that those provisions have worked well for 20 years. Very few prosecutions have succeeded, and when they have succeeded, they've been in particularly egregious cases, the Bolt case being one of them. The facts were wrong, and the judge found there was no element of good faith, and therefore the right to freedom of speech did not apply. But I'd suggest to you that there has never been a more important time to stand up for laws which prohibit racial abuse in the public arena. Sadly, you can say what you like around the kitchen table at home, but you cannot abuse people. And I don't believe we should abuse people because of their race in the public arena in a way that is interpreted by the federal courts usefully as being much more than mere insult, but having profound impact. We know that the phrase my grandmother used to use, "Sticks and stones shall break my bones, but words will never hurt me." My grandmother was wise, but she got that one wrong, because words do hurt, and they actually hurt more than a broken bone in the end, because there's a lot of social science. When people are regularly discriminated against and fearful of how they're going to be treated because of race, it has a profound impact on them and their families and their ability to flourish in their societies. I think that we need to stand up for these principles of behaviour in the public arena. Race hatred is an ugly phenomenon, and it's one where we need leadership to ensure that it doesn't occur. These, of course, are difficult times when we have the Trump ban on entry into the United States on 6 predominantly Muslim nations. That has been rejected by the courts twice so far, but perhaps most encouragingly, and I think this is a very positive point to make, it's been rejected by the senior business leaders throughout the world. Uber, Microsoft, Google, the big mining companies, they have all stood up to say that ban on migration does not meet their business values. And one of the things that I've found in my job is that it's the business community that is actually now leading on meeting many of these human rights and indeed environmental concerns. Well, I should conclude. I think my main thesis has been that Parliament and the courts have failed to protect some of the most vulnerable in our society. We have a history of recognising human rights and protecting civil and political rights, but we have let down sectors of our community very badly. I'm particularly concerned about the growth of autocratic governments and the growth of discretion that's not subject to judicial review. I think we should be alert and alarmed by the growing abuse of the rule of law and the debasement of many of the principles by successive executive governments. But what are the options when Parliament fails to exercise its traditional restraint when enacting laws? What can we do when a majority government, sometimes in collaboration with opposition parties, passes laws that explicitly and without ambiguity breach our freedoms in the interests of national security, public order, border control and law and order, or even to save the police having to carry out paperwork? I suggest that serious consideration should be given yet again to the need for a federal legislated Bill of Rights, so that our courts can constrain the excesses of indefinite detention and cruel treatment, that they have a benchmark against which to determine if our laws adequately protect our rights. As a nation, we need to agree upon the core principles against which the benchmarking and the discipline of executive power can be measured. Well, what can we do as citizens? I suggest, and I notice that you have a new project here, that we, as citizens, that we stand up, that we reject slogans and superficial thinking, that we insist on evidence-based policies and on law and on evidence-based laws. It was very encouraging, in addition to the business community, to see 21 CEOs sign a letter to the Prime Minister demanding equality before the law for those of different sexual orientation. That was quite a brave act, one for which I think Alan Jones was told to go back to his knitting. He said, "My knitting includes a just and fair provision of airline services, and I'm going to stick to standing up for equality before the law." Perhaps I should remind you that Australia is seeking a seat on the United Nations Human Rights Council. The vote will be held in October this year. My personal view is that we should win that vote, both because Australia can lead in our region in promoting human rights, and because our membership might have some persuasive influence on our politicians to meet our obligations under human rights treaties. Well, human rights advocacy is not for the faint-hearted, but I do urge you to speak up. In an age of so-called post-truth, it's more important than ever that we counter the spin by many in the media and the political arena, the distortion of facts and the abuse of freedom of speech, by presenting the evidence and standing up for the rule of law. Human rights are not the domain of left or right politics. Human rights are there to protect the most vulnerable in our communities, to redress the imbalances between the powerful and the powerless, and to advance fairness and equality for us all. In these post-Brexit and US election days, I do believe that we need to reach back to those that we've left behind to ensure that they have a voice and they're integrated in all that our contemporary society can offer. Finally, we can respect and rely, and this is very important to us at the Human Rights Commission, on the common sense and the goodwill of most Australians. It's the culture of equality and fairness that in the final analysis will protect human rights. You can have all the laws in the world. If we don't believe in them as a society and stand up for them, then they really won't matter. And that's the reason why I think that the principle of a fair go is alive and well in Australia, but we need to build on it to ensure the rights for everyone. Thank you very much.
Thank you, Gillian. What a remarkable speech. What a remarkable exhibition of leadership when it's needed. What a remarkable ability to say to us, we should speak up by example. Here is a champion of free speech that this country, with its record of Doc Evatt and so many others in the past, knows is still alive and is still well and is still of world standard. Gillian, we are very pleased you are here tonight. The Australian got it very right. It said it thought that you would be accorded, you might be embarrassed by this, a hero's welcome here in Hobart. We certainly think you are a hero of human rights in an age which greatly warrants it. Thank you for coming to speak with us in Hobart tonight.
Thank you very much. Thank you. Thank you very much. Thank you.
Gillian did offer to take questions, but we've had a wonderful oration. I think we'll call that a night. She'll be here for a while to speak with folk before we go to dinner. I ask you to look out for the 8th Hobart Oration. But once again, I thank you all for coming, for listening to this critically important topic tonight, for hearing an Australian challenge, not just our courts, but our parliaments. And that means challenge us as citizens, because when it gets down to it, this is a democracy, it is ours, and what happens in Canberra or in Hobart or any of the other parliaments is a reflection of what we put into it. So there we are, it's a celebration of democracy tonight, and our speaker, Professor Gillian Triggs, has given us a wonderful presentation of just that. Thanks, ladies and gentlemen. I just add a special apology from Christine Milne, who's at an international conference. She wanted badly to be here tonight. Well, I'll tell her all about it. Thanks.